clearly you've all got different backgrounds, you're at different levels of expertise within the sector, and so I thought what I would do is start with a sort of a general warm-up. And this is not a teaching exercise as such, it's me telling you what's been going on in the sector over the last year or so. There have been proposals for changes in the law, some of which you might have heard about at differing levels, and you might have heard snippets and thought, what on earth is all that about? Well, I'm going to do my best to tell you what it's all about. So I thought I would start with that. And then we will go into what I call a slightly more teach method, which is me telling you what your fundamental duties are, and something about your legal structures, which will all be quite different. And then we're going to finish off with a case study, which hopefully will make you laugh. It's one of the most awful charities you will ever have seen in your life. And there is nothing in this charity that appears to be right. So I'm expecting you to put it right, basically. You're going to have to do a bit of work at the end of it. So I'm going to start, as I say, with the Warm-Up Act. I call it the State of the Nation. Can you all see that okay? Okay. The charitable sector has been very much in the news over the past few years. And while some of the coverage has been very good, some of it has perhaps not been quite so complimentary. And it won't have escaped your notice that what I call the new austerity is affecting all walks of life. Banks, FTSE 100 companies, public bodies, our esteemed members of Parliament and charities, they're all under the spotlight at the moment. And so far as charities are concerned, there is an expectation that they will provide public benefit, that private benefits and conflicts of interest will be minimal, that trustees will give of their time on a voluntary basis, and that chief executives will not have high salaries, you've probably read about that one, and that corruption, tax avoidance and breaches of trust should be dealt with firmly by the Charity Commission, which is the main regulator, and also by HMRC, our lovely tax collector. But I don't think that any sector is beyond reproach or above review. Now, under the Charities Act of 2006, which introduced some quite sweeping changes in charity law, the Minister for the Cabinet Office was required to undertake a review of the legislation at the end of 5 years to see whether or not it was working in the way that it was intended to work, taking account of any significant political, economic, social and technological changes that have occurred since the Act was passed. Now, of course, there's been a significant change in the global economic situation since the Act was passed, which have directly affected not only charities, but also the Charity Commission, which has seen its budget cut in real time by something like 40%. Now, the Charities Act itself has been thoroughly reviewed over the last couple of years, and the process is ongoing. Somebody called Lord Hodgson was appointed by the Minister to do this, and he reported to the House of Commons in July of last year. And some of his recommendations were then referred by Parliament to the Law Commission, and others were passed to the rather wizzily titled House of Commons Public Administration Select Committee. I'll say that 10 times quickly. Now, the Select Committee gathered a significant amount of evidence in its own right before coming to conclusions which were published in May of this year, and this was followed in September by the government's response overall. Now, one of the key changes that was introduced by the 2006 Charities Act was the imposition of the public benefit test. Now, to be a charity, an organisation must be established for a purpose which is charitable, and that purpose must be for the public benefit. Now, the Act removed any presumption of public benefit that might have existed before the Act was passed, and it required the Charity Commission to issue guidance on the public benefit requirement. But what the Act failed to do singularly was to define what was meant by public benefit. In effect, this was delegated wholesale to the Charity Commission, which led to some rather well-publicised legal cases through the Charity Tribunal, which were brought by the Independent Schools Council, among others, and that was a challenge, direct challenge to the Charity Commission's guidance. Now, Lord Hodgson's report recommended that there should be no statutory definition of public benefit, so as to retain flexibility and allow the common law to develop in the way that it usually does. However, the Select Committee, which was cross-party, so you had every political persuasion going in there, they disagreed, and they highlighted the challenges to the Charity Commission's guidance on public benefit and its impact on schools and religious organisations. Now, that guidance was successfully challenged by the Independent Schools Council, and in particular the part that said that high fee-charging schools must demonstrate that people in poverty can benefit, and in effect that a school wouldn't be a charity if it couldn't do that. Now, a further challenge is in the offing concerning the Charity Commission's refusal to register the Preston Down Trust which is part of the Plymouth Brethren Christian Church, on the grounds that the Commission was not satisfied that this trust was exclusively charitable for the public benefit. The trust application for review by the tribunal has been stayed at the request of Parliament, who were really cross that the church was being challenged on this basis for public benefit, so that the parties can try to find a more cost-effective way of resolving the issues. But these examples led the Select Committee in Parliament to conclude in its report that the Charities Act is critically flawed on the issue of public benefit, in that it requires the Charity Commission to give guidance on public benefit, which left it in quite a difficult position, as evidenced by the rather costly legal battles with those who disagreed with the Charity Commission's approach, and especially where the issues are complex and they touch upon controversial and sometimes political issues. Now, the Select Committee said that Parliament must legislate, with some emphasis, to clarify the position, and recommended that the removal of the presumption of public benefit, which, as I said earlier, was thought to exist, they recommended that that should be repealed, along with the Charity Commission's statutory objective of promoting the public benefit requirement. And it also said that if Parliament wanted to impose new conditions for what constitutes a charity, and qualifies for tax relief, more to the point, it should bring forward legislation, and it shouldn't leave it to the Charity Commission and to the courts. Well, guess what? The government has completely disagreed with that committee's conclusion. It said, we support Lord Hodgson's conclusion that despite the shortcomings, public benefit is best left to case law rather than for Parliament to try to define it in statute. No one has yet been able to adequately describe what a statutory definition would be, given the vast array of charitable activities that go on. They're all different. It said Parliament should define the criteria for charitable status, and the Charity Commission should decide whether an organisation meets that criteria. But the government didn't rule out the possibility of creating a statutory definition in the future, depending on how the case law developed. So, let's be cynical. If they don't like what the courts decide, they'll do something about it then. So the Charity Commission has now issued some new public benefit guidance, which is far less dictatorial and leaves trustees to decide how best to provide public benefit. Now, I mentioned the Charity Tribunal in the context of the challenge to the Commission's guidance on public benefit. Now, not all decisions of the Charity Commission can be challenged through the Charity Tribunal. There are some limitations at the moment. And the tribunal was intended to be a cost-effective way for litigants in person to appeal against decisions of the Commission. But this hasn't proved to be the case, and a few very high-profile cases have been heard by the tribunal with no fewer professional advisors than one would see in the High Court. And litigants in person have appeared, but not as many as have been thought. But Lord Hodgson recommended that there should be a right of appeal to the tribunal against any legal decision of the Charity Commission, so anyone should be able to go along and do it. This didn't find favour with the Select Committee, which said that the Charity Commission, they really didn't like the Charity Commission, by the way. They noted that the Charity Commission was placing a lot of reliance on the tribunal to resolve contentious areas of law, and that in practice the costs were falling on charities, taking away vital funds, as they said, which could have been used to fulfil their charitable objectives. Now, the Select Committee called this an abdication of responsibility by the Charity Commission and an expensive, time-consuming and rather unjust way to test the law. It said the tribunal had failed in its objectives to reduce the cost of disputes, and said that the Commission should devise some informal dispute resolution procedures and shouldn't use the tribunal system as a means of testing the law. Well, the Commission wasn't at all happy about this, especially given their reduced budget, so they started to consult the public to see what they thought about it. But the government also disagreed with the Select Committee. It said the whole purpose of the tribunal was to facilitate the development of charity law, and said it was up to charities how much they chose to spend on their lawyers. The government didn't agree that the Commission was abdicating responsibility by referring difficult cases and points of law, and the government also agreed with Lord Hodgson that the rights of appeal should be widened. So I think that's something like 3-0 to Lord Hodgson so far. The Select Committee said that the statutory objectives of the Commission were too vague and aspirational, and that this was the case even before the rather drastic cuts in the budget had been announced. Objectives such as promoting the effective use of charitable resources and promoting public benefit was not something, they said, that the Commission could or should do. The Commission should focus, it said, on its core role of regulating the sector and preventing use of charities for tax avoidance schemes. Now, this was a reference to a tax avoidance scheme which made the headlines earlier this year. The Commission had registered a body called the Cup Trust in 2009, And by 2010, they'd already opened an inquiry into its activities. Now, this charity had income in 1 year of £176 million, of which only £55,000 had been spent on charitable activities. Go figure. It had a corporate trustee, which was resident in a delightful offshore location. I think it was Bermuda. It engaged in tax avoidance schemes, which were beneficial to wealthy donors, but did manifestly little for charities, as evidenced by the rather small sums of money that they were shelling out. The Charity Commission, however, closed its inquiry, and they didn't take any regulatory action. Then the Times newspaper got hold of it, and they ran a story on it in January of this year. And then the Public Accounts Committee, which was chaired by Mrs. Margaret Hodge MP, was extremely critical of the fact that the Charity Commission had registered the Cup Trust in the first place. It expected a higher level of due diligence, it said, from the Charity Commission when bodies applied for registration as a charity, and especially where there was a corporate trustee based on a lovely offshore location, traditionally associated with tax avoidance schemes. The Public Accounts Committee said that there should have been far more liaison with HMRC, which would have elicited information about the directors of this trust company, who are apparently well-known tax avoiders and well-known to HMRC. Now, what I think is that whilst the Commission could have done more by way of regulation after it had opened its inquiry, for example, they could have removed the offshore trustee and they could have appointed some English trustees to replace them. I think the Public Accounts Committee was rather extreme in its condemnation of the Commission and seemed to be unable to recognise how the cuts in its budget might have had some effect on its performance. And I also believe, after years of giving advice on charity law, that the number of incidences, actually, of charities being involved in tax avoidance is really, really small. I mean, it was just a sledgehammer to crack a nut. Now, sadly, of course, when it does happen, it's blown out of proportion by the press, and it brings the charitable sector into disrepute overall. And that, along with the rather large sums of money which have been raked in by a few individuals, is why the Cup Trust saga caused such an outrage. Now, Mrs. Hodge expressed her disgust with the Charity Commission in no uncertain terms. There she is, God bless her. Now, thankfully, the view of the Select Committee was a bit more balanced, and with reference to the Commission's statutory objectives, the Commission agreed that the focus should be on regulating the charitable sector, but said that the Commission doesn't have the means to investigate tax avoidance and fraud. That's the role of HMRC, which is better equipped and financed to do it. It thought that the Commission should prioritise the investigation of potential sham charities and work more closely with HMRC, but said that ministers should decide whether they think it's necessary to have a proactive regulator, and if so, they've got to give the Commission an increased budget. Or, if they can't find one, then the ministers should be explicit that they accept that the regulatory role is of necessity going to be limited. And the government has accepted this because there is no more money. But it said that the Commission should retain its public benefit objective, albeit without such a significant focus on its resources. Now, there's been a lot of adverse publicity about the Cup Trust this year, and public sentiment is firmly against charities being used for tax avoidance purposes. And I agree, but I hope that they don't use a sledgehammer to crack a nut and add to the burden of regulation, which already falls on trustees of charities. But unfortunately, HMRC is not the only body which is looking to take money from charities. Local authorities are assessing charities where they have wrongly claimed business rates relief. As you probably know, charities are eligible for relief on the premises which they own and occupy for their charitable purposes. Now, the Public Safety Trust appealed this year against assessments for business rates relief just a few months ago. And what happened in that case was that private property owners had granted very, very short leases at a peppercorn rent to the Public Safety Trust. And its occupation consisted of putting Wi-Fi equipment into the premises. So you've got these otherwise empty rooms, but with a small machine in the corner. And the effect was that people with mobile phones who were passing by could pick up safety messages from the Wi-Fi equipment. Now, in effect, the court said that this wasn't really a sufficient use of the premises for charitable purposes, so the charity wasn't eligible for rating relief. Now, that was incredibly expensive. In fact, the charity had to fold because it lost 80% mandatory relief and the 20% discretionary relief which local authorities can give you. I suppose the moral is that charities shouldn't be tempted by what might seem like a good deal, unless they're certain that they can make some real and substantial use of their premises. Now, the Select Committee said that self-regulation of fundraising, and in particular the so-called chuggers, has failed to give the public confidence, which is essential for the reputation of the sector. Now, public fundraising has been an area that no one wants or can afford to regulate, and it's been this way for a very long time. Attempts were made to provide for a proper regulatory system in the Charities Act of 1992, but those provisions were never brought into force, and likewise a framework for regulation was included in the Charities Act of 2006. But the Charity Commission estimated that the cost of regulating fundraising, and the legislation gave the role to the Commission, they said it would be £4 million a year, let alone the start-up costs. And now the Select Committee said that the case for regulation was compelling, but it had to be balanced against the cost to the public purse and to charities, and it recommended that the self-regulating bodies, of which there are 3 apparently, should be put on notice that they've got to increase membership of the fundraising standards body, they've got to improve compliance with its code, and they've got to strengthen public awareness of their complaint systems. Now the Select Committee recommended that the position should be reviewed in 5 years, and if it becomes necessary to regulate by statute, then it's recommended that charities should pay for it, with perhaps an exclusion for traditional street collections such as Royal British Legion, RNLI and the local hospice movement. And the government has agreed with this approach, so the sector is now on notice, they've got to get their act together. There was a debate about whether or not the rules on political campaigning were at the right level. Now, of those who gave evidence, some were for declaring complete glasnost and allowing charities to spend all of their money on campaigning work where it furthers their charitable objectives to do so. Others didn't like that idea at all, and they wanted the Charity Commission's current guidance to be rescinded and for much tougher rules to be reintroduced. Now, the Charity Commission figures show that, in fact, there are very few cases of wholly inappropriate political campaigning activity. And the Select Committee weren't convinced by the arguments for either side for any change. So the government agreed and said that preserving the status quo promoted charities' independence and their important campaigning and advocacy roles. The government also agreed that transparency should be encouraged and that charities should publish the amount of their expenditure on campaigning and political activity in their annual returns. So not too much change there for the moment. Now, another sector under discussion was think tanks. They're usually set up with objectives to advance education by, for example, conducting and publishing research on the economy and politics, and then they hit the government with it at every opportunity that they can. Now, sometimes those bodies promote a particular political point of view, and they fail to maintain a neutral stance, and the courts have consistently held that it's not permissible in law to be political because it's non-educational. And it doesn't promote an educational purpose. But it does happen on the left and the right of politics all the time. So the Smith Institute was founded by the Charity Commission to be promoting Labour Party policies, quite overtly. And then Atlantic Bridge, which was Liam Fox's case, you may remember, that was found to be promoting extreme right-wing policies. Now, the Select Committee were concerned by reports that the Charity Commission might not have been regulating think tanks in a fair and consistent way. But on balance, the Select Committee was satisfied that, subject to some new Charity Commission guidance being prepared for its staff on this rather special area, there is still a place for think tanks in the charity environment, and the government has supported that, so they can carry on doing what they do. The Select Committee recommended that there should be no fees charged to those who want to apply to register a charity. Now, this is something that Lord Hodgson thought was a very good idea, but they did think that a proportionate and flexible system of charging charities which are late in filing their annual returns should be developed, and the government agreed with that. And the Charity Commission is now pushing ahead with this one. I think it will probably come into force next year. Payment of trustees. It continues to be a controversial topic. Lord Hodgson recommended that large charities, by which he meant those with an income in excess of £1 million, he thought that they should have the power to pay their trustees just for being trustees, not for providing any service, just for being a trustee, as long as the payments were disclosed in the charity's annual return. Now, the government's interim response was to reject what it called the easing of that general presumption against trustee remuneration, which I will come on to talk about a bit more. and the Select Committee endorsed that view and said that it would undermine the voluntary principle which is central to the whole ethos of the charitable sector. So no change for now, but I don't think this question is going to go away. There are lots of people in favour of it. Now, Lord Hodgson recommended that the 35,000 or so registered charities, which are also companies established under the Companies Act, he recommended that they shouldn't have to produce two separate annual returns for the Charity Commission and Companies House. And the NCBO has also said that there is an administrative burden for charities which operate in England and Wales and in Scotland and in Northern Ireland, as they have to file separate accounts in each jurisdiction, in addition to dealing with different definitions of public benefit in England and Scotland, and that the various regulators have been unable to resolve this. Well, it's hardly surprising. It was Parliament that caused the problem in the first place, but there you go. Now, the Select Committee and the Government agreed that there should not be a need to file returns with both Charity Commission and Companies House. Those bodies should agree what's required, and the records should be kept in one place rather than in two. And this should be a priority to save costs for the Commission and also for charities. And whilst the Select Committee and the Government recognise the hands-off nature of devolved power, it said that the Charity Commission and the Office of the Scottish Regulator shouldn't be subjecting charities to regulations which are different in each different jurisdiction, or be imposing different conditions for registration. It's a waste of money. Well, I think they're going to have to change the law. Lord Hodgson was very keen that trustees should not serve for more than 3 terms of office of no more than 3 years in each term, so 9 years in total. He thought that this should be a requirement in every charity's constitution, and that any charity which didn't comply should be required to explain why in its annual report. Now, the Government thought that this should be best practice rather than the law, and it said it would work with the Charity Commission to determine if it was appropriate or even proportionate for there to be a disclosure requirement. But Lord Hodgson is not at all happy with this, and he said that he's going to continue to campaign for it on the basis that once you've been a trustee for some time, you become stale, which isn't in the best interests of a charity. Now, this has been an ongoing debate for a considerable amount of time, and it's not a new idea, but it might be adopted for more charities as the norm. The Public Accounts Committee was extremely unhappy with the role of the Charity Commission around regulation of charities, and it has asked the National Audit Office now to review its performance and ask questions about whether it's fit for purpose. So the Commission has got that to look forward to. That report should be out later this month. The Law Commission has yet to look at and make recommendations in relation to a significant number of proposals by Lord Hodgson and the Select Committee for legal change, and that includes short-circuiting some of the long drawn-out processes for changing your governing document if you're a royal charter body or a charity established by Act of Parliament, of which there are quite a lot. The Commission is also going to look at increased trustee autonomy over disposals and mortgaging of charity land, schemes and failed public appeals, which can cause a lot of grief, ex gratia payments out of charity money, reforms to the powers of the Charity Commission, the Tribunal, charity insolvency law, mergers, incorporations of charities. There's a whole raft of things that are being proposed. It's a big programme of law reform, and the Law Commission will be consulting with the public and reporting to Parliament next spring. Now, this is likely to be followed by the introduction by the Commission of draft legislation, which will start in the House of Lords by convention. And what this means is that there will be a much more considered debate on the legislation than happens when it goes into the House of Commons, which is a complete scrum, and you get rubbish coming out the other end. Now, apart from, I'm not very respectful about the House of Commons. Apart from the Law Commission's work, there is nothing major by way of law reform coming out of the various reports which would require the government to introduce any legislation. So the only way in which there could be additional legislation, for example on the controversial issue of public benefit in private schools, would be through a private member's bill or, of course, if a new government is elected. Now, on that, we're just going to have to wait and see. I don't think that there's going to be any change soon on public benefit, but the issue about fee charging schools is not going to go away. People feel strongly about it. Now, Lord Hodgson recommended that there should be a joint registration process for charities involving the Charity Commission and HMRC. At the moment, the charities have got 2 different registration processes to go through. Usually the Charity Commission comes first, followed by HMRC. Now, his report is looking at this from the viewpoint of the administrative burden on charities, which he thought could be solved if there was only one form to fill in rather than two. And so the Commission and the HMRC are now working on this, and I can see no objection to it as long as it doesn't end up with a situation where the Charity Commission can't accept a body for registration unless HMRC has agreed with it. The regulators have got quite different roles, and HMRC has got a financial interest in all of you, because if you don't qualify as a charity, you pay tax. In my view, therefore, it would be a mistake if HMRC was able to muscle in on that decision-making process. Now, there is no suggestion that that is the case, but I'm a great believer that mission creep can sometimes come in and get in the way. So you might ask, what has all this got to do with us? Well, so far as regulation is concerned, HMRC's presence is going to be felt much more than it has been in recent years, and charitable tax privileges will be curtailed where, for one reason or another, there has been a breach of the rules. It's vitally important, therefore, that trustees and senior staff review their governance practices and their procedures, the extent of the authority that they are delegating, to ensure that there are proper controls in place over your money, and that it's being managed properly, and that, of course, there is nothing like fraud going on. You can't avoid it, but you do your best to stop it, and tax avoidance, heaven forbid. Now, the management of conflicts of interest, it continues to bedevil the sector, and that also needs to be brought under control, and I will be talking more about that in a minute. The Charity Commission's light touch approach to regulation has disappeared already in charities with assets or money of any significance, and we are now seeing an increase, a big time, in regulatory activity by the Charity Commission, which was badly stung by the criticism of the Public Accounts Committee. The Commission is getting tougher on charities which file their accounts late, and it's advising donors not to give to charities which file late. And we recently saw the opening of an inquiry into the Dove Trust, which is very sad. This is where the founder, who was also a trustee, he lent the charities money, no control from his co-trustees. He lent it to his property investment business. The lending was unsecured, and it looks as though the charity isn't going to get its money back because that property investment business has failed. And another inquiry is looking at an evangelical charity where the trustees appear to have been motivated by some significant financial conflicts of interest. We wait the outcome of that one. I think the impact of the Charity Commission's reduction in funding shouldn't be underestimated, coming as it does at a time when charities are also suffering overall a significant drop in their income. The recession has hit many charities, and I think for the smaller ones, the significant scaling down of the Commission's advisory functions, which are free of charge, will be felt quite keenly. There's been talk of some of this advisory work being taken on by the sector, and Lord Hodgson was quite keen on this, but the NCBO has made it clear that the sector can't afford to do this without adequate funding in place. So this means that small and medium-sized charities are going to be left without access to free sources of advice and guidance, and they're going to have to turn to professional advisors if they're not to get into hot water. Now, overall, I think that there has been a change in the mood of the public, and in line with the less tolerant approach to tax avoidance, which is being seen in the corporate world, a la Starbucks, etc., and a more questioning approach to some of the behaviour of our parliamentarians, and others who hold public office. Trustees should anticipate increased scrutiny of their activities by the media and the press, who are only too happy to tell everybody what's going on, and also by the public and HMRC. There's a growing awareness also among general members of the public about the tax privileges that charities have, and an increasing expectation that those privileges should be withdrawn if there's any abuse. Now, of course, these things always produce a dichotomy for charities. Various surveys carried out over the years, they show the way that the public view charities, and the position doesn't really change. The public expects charities to be well run, but at the same time they don't expect trustees to be spending large amounts of money on administration. And I think somewhere in the middle lies the answer to this, and the annual report is actually quite a good way to explain what charities do, and if they are spending high sums on administration, and there's a good reason why they're doing it, they can tell the public why and how they benefit from it. So in this session, I'm going to talk about how charities are regulated and the role of the Charity Commission. The concept of charity, it began in medieval times. It's been around an awful long time. It began with religious orders of monks who performed charitable acts. So relieving poverty, advancing religion and teaching the young how to read and write. They are the oldest charitable purposes that we have. Now, to be a charity, an organisation must be established for a purpose which is regarded as charitable in law, and it must exist for the public benefit, as I spoke before. Now, the Charities Act of 2011, it codified the law on charitable purposes. Now, as I mentioned in the previous session, there has been a lot of controversy about the need for charities to demonstrate that they exist for the public benefit. It's largely perceived to have adversely affected religious organisations, independent schools and other fee-charging charities. But all charities must be for the public benefit. And in reality, in my view, the law relating to public benefit hasn't changed in any material respect at all. It is and has always been a requirement that to be a charity, you've got to be for the public benefit. What has changed since 2006, as I said, is this legal burden of proving public benefit. In all cases, it now falls on the trustees of a charity. And the annual report and accounts must demonstrate how you satisfy the public benefit test. There's a lot of guidance on the Charity Commission's website about meeting the public benefit requirement, and the Commission has also given you some worked examples of how the public benefit statement should be presented in your annual report. But public benefit reporting is not a formulaic exercise. You must set a strategy for the charity in advance, and the provision of public benefit should be right at the core of that strategy, nothing else. So I put some links on there for you to some of the guidance that we have. So I'm not going to say any more about charitable status. You should become familiar with the governing document for your charity. Now, different legal consequences flow depending upon the legal form that you have adopted. The governing document tells you what your charitable purposes are, how your trustees are appointed, what the powers of the trustees are, and whether or not you have a membership structure. Now, charities can be established in a number of different ways, and the legal form for your charity is really very important. The most common types of governing document that we have are the company limited by guarantee. This has a memorandum and articles of association, and it's regulated by the Companies Act as well as by the Charities Act. It's run by directors, and it must have members. Now, the membership can be big or it can be small, and sometimes the members are the same persons as the directors. Secondly, we have the trust. It's usually governed by a trustee, sometimes by a will, and sometimes even a conveyance of property will include a trust. They were commonplace up until the 1950s. Trusts do not have a membership. If you see a trust with a membership, something's gone very wrong. They are governed solely by trustees, and the trustees can be individuals, they usually are, but sometimes you get a single trustee, which is a company, a corporate trustee. Now, the third one is an unincorporated association. It's governed by a set of written rules, and it must have a membership. And its trustees are quite often elected by the members at a general meeting. And then we have other less common types of constitution. There's the Royal Charter Body, charities governed by statutes such as the RSPCA and the National Trust. And then we have industrial and providence societies, and many housing associations are set up as IMP societies, as we call them. Now, there is a new legal form available called the Charitable Incorporated Organisation, or the CIO for short. I'm still not recommending to my clients that they set themselves up as a CIO. They're largely untested, and there are still quite a few problems with them. For example, unlike a company limited by guarantee, there is no public register of charges. And so banks and creditors, they can't tell if a CIO is financially sound or if his assets are mortgaged up to the hilt. There's no way of knowing. There's no public register. So it could be difficult for a CIO to raise money through borrowing, and so I'm not recommending them. The perceived advantage of them is that there is only one regulator, the Charity Commission, rather than two. Now, unless you really are a horse and pony act with nothing else, actually, the cost of regulating, of going to the Companies House and Charity Commission really is not such a big deal. It's not very expensive. Now, the charity trustees of any type of charity are the persons who are charged with that legal responsibility, the legal responsibility for running the charity. Although in the case of larger charities, and like any other company or organisation, the trustees often delegate the running of the charity to a smaller number of trustees acting through a committee, or possibly to employees such as the chief executive and the finance director. But the buck stops with the trustees, who aren't necessarily called trustees in the governing document. They could be called directors, council members, board members, court members, the management committee, the executive committee. They have all sorts of names. It doesn't really matter what they're called. What matters is who is responsible under the governing document for the management and the administration of the charity. And those persons are the ones with specific fiduciary legal duties. Now those duties arise under the common law and increasingly under statute. There is a wealth of case law on the duties of trustees, and the Charity Commission also regulates them, and they're called charity trustees in the legislation. Now again, the legal duties of trustees for the management of the charity and its money, it goes back hundreds of years in history to the courts of equity, which realised very early on that the law needs to provide for specific legal duties to apply to those who are responsible for safeguarding charitable money and assets. Now, of course, we all know that in the real and the modern world, most trustees are volunteers, and they don't, as a matter of course, get involved in the day-to-day business, unless the charity is very small and it doesn't have any employees. But usually they will employ chief executives or finance directors and other staff, and they expect staff to carry out those legal duties for them, in effect. Now, whatever your position, you might want to think about who complies with the legal duties that I'm going to talk to you about within your charity. The reality is that the job of ensuring that trustees comply often falls to the staff, the chief executive, etc., even if there isn't anything in the job description, or even where it is, under a sometimes nondescript heading, which I've seen before, complete all filing and compliance work. Marvellous. Now, the primary duties of trustees, they are to observe the terms of your governing document, to safeguard the assets of your charity, and to avoid conflicts of interest. So let's go through those. What does it all mean? Observing the terms of your governing document. It means to ensure that everything that trustees do is calculated to further your charitable objects as set out in your governing document for the public benefit. You should be aware of mission drift. It can happen, for example, where those responsible for getting in the charity's money and their funding, they get carried away in those efforts to secure a funding stream, and before you know it, the charity can end up doing something which doesn't fall necessarily within its charitable objects. This is a real risk in times of recession when money is tight. It also means ensuring that your organisation has got the power to enter into a transaction. Now, just to give you one example, some charities have a wholly owned trading subsidiary which carries out fundraising activities and then donates the profits to the charity at the end of the year. It's a tax efficient way of doing it. Now, if the subsidiary is short of working capital, it might ask the trustees of the charity to lend it money or to guarantee the repayment of its bank borrowing. Now, lending and guaranteeing the debts of a subsidiary, a trading subsidiary, are not something that a charity can do without a very clear power of investment, because that's what you're doing. If you're putting money in your trading subsidiary, you are investing charity money. Now, the subsidiary is not a charity, and the trustees can't prop it up if it's in financial trouble. This is another common mistake. And I'm going to say a bit more about this later. The point here is that you need to take care that you have enough powers, and more specifically that the powers you do have are adequate to cover the situation that you're looking at. Secondly, a duty to safeguard the charity's assets. Now, this rule manifests itself in a number of different ways. Basically, it's about using legal rules and the rules of good governance to ensure that your charity is well run, so that the assets and the money aren't dissipated through incompetence or fraud. So, for example, what does your governing document say about delegation of the trustees' powers to manage the charity, and then what happens in practice? There are two types of delegation, and the first is where trustees delegate a specific task to someone. For example, delegation to the finance director of the task of buying an IT system at a given price. And the second is where trustees delegate, either with or without agreeing a budgetary limit. They delegate to the finance director the task of hiring and firing of staff. The first is a set task. You can see what you've done and you can see what you've delegated, that's fairly clear. But the second is much more open-ended, and it involves a lot of subjective decision-making on the part of the person to whom you've delegated. So you need to have very clear guidance. Trustees might delegate to staff the management of bank accounts, or entering into and signing of contracts. Now, the rules in your governing document should be observed, and also there should be safeguards to protect against fraud. Now, it's commonplace to see the power for trustees to delegate tasks in the governing document, but it's unusual to see a power to delegate to staff, including the chief executive and the finance director. So do have a look at your governing document and get it amended if necessary, following the correct procedures, and then document very carefully the extent of the functions which the trustees have delegated and to whom, and include financial limits. They shouldn't be left open-ended. If you see one trustee or one employee taking decisions without a proper mandate from the board, you should be on your guard. Now, in addition, the trustees should supervise delegates very carefully at every level, and they should require frequent activity reports on what they're doing, especially where money is being spent. If one person is authorising the signing of contracts, and they're also signing the cheques in fulfilment of those contractual obligations, then in my view the trustees have not taken steps to safeguard the charity's assets, because there is no check and balance in place on what that individual is doing. Now, for those of you who are lucky enough to have investments, some of you might have some money lying around, I haven't, what are the powers of investment of your charity? And going back to the subsidiary company, include that within it. Some charities have got a portfolio of investments, or they might own property which they let for a commercial rental income. Now, as I mentioned earlier, putting money into a trading subsidiary or guaranteeing its debts amounts to the exercise of the trustee's powers of investment. And there's a lot of law and good practice which applies to the powers of investment and the duties that go along with those powers. Trustees should invest for the maximum return, nothing less. And you have to comply with the spirit of the Trustee Act of 2000 and the general law. Now, the legislation and the general law impose a standard of care on trustees when they're making investments, and it requires them to have regard to something called the standard investment criteria. Now, the standard investment criteria, I've gone too far, they require trustees to have regard to the suitability of investments and to the need to diversify your investments. A trading subsidiary may not be a suitable investment for your money. The trustees must also review the investments from time to time and consider whether they should change them, having regard to that standard investment criteria. And then finally, before making any investment, trustees should obtain and consider proper advice, unless they conclude that it's unnecessary. Now, the Trustee Act of 2000 gives trustees also power to delegate investment management. They have a wide discretion as to who they appoint to do the job for them. They've got a duty of care in selecting their investment manager and agreeing to the terms on which the manager acts. You have to have a written agreement with your manager, and you have to have a written policy statement which tells the manager what they've got to do. The policy statement must give guidance to the manager on how that investment function is going to be carried out. And the preparation of the policy statement is the responsibility of the trustees, and they've got a duty of care when they do it. So it can't be delegated to the investment manager. Now, overall, even if trustees are able to justify investment losses, which can easily happen in a fluctuating market, or the holding of assets of a particular class, the lack of a fully compliant agreement is something the Charity Commission will pursue if they are investigating a charity. Now, as to disposing of land and buildings, we have Part 7 of the Charities Act, and that has to be complied with. What Part 7 does is provide that whenever a charity wants to sell or let its land, or sell its land and buildings, the trustees must, before they enter into the contract, they've got to instruct a surveyor to advise them in writing on whether the terms of the disposal are the best that can be reasonably obtained. And the trustees must decide collectively if this is the case. But if a disposal is to a connected person, trustee, family, or a wholly owned subsidiary, then the consent of the Charity Commission must be obtained. Now, there's also guidance on the Commission's website, which I put on the screen, about acquiring land and buildings. It's worth having a look at. It's quite detailed. Now, it's important that the rules in your governing document are observed concerning the appointment and retirement of your trustees. And if not, it's quite possible that your charity isn't properly constituted. And the consequences of this are that if a contract on behalf of the charity is made by someone who's not properly appointed as a trustee, that person could be personally liable to deliver on the terms of the contract, but without being entitled to an indemnity from the charity's money with which to meet it. So do check to make sure that the rules are being observed. Now, there are different ways in which trustees can be appointed. Sometimes the trustees simply have the power to appoint other trustees. Sometimes the charity's founder has got the power to appoint trustees. And in a company, the members might appoint trustees, either at an annual general meeting, and sometimes it's by postal ballot. Many charities have ex officio trustees, post holders. So, for example, the chairman for the time being of a named body might be entitled to be a trustee, and it could be a local authority or someone from where they come from. Or a named body might have the power to nominate trustees. That's quite commonplace in local community type charities. Third duty, avoiding conflicts of interest. As I said, this bedevils the charitable sector. It's always a thorny subject. And as I mentioned, in the context of Lord Hodgson's recommendations and the government's response, there is a basic legal presumption that trustees should act in a voluntary capacity. So a trustee shouldn't be a paid employee, and neither can he contract with his charity to buy or sell goods, land and buildings, or services. It's called the self-dealing rule. Now, there are some exceptions to that basic rule. And the first one is, it's where the governing document expressly permits a particular benefit or situation to be permissible. It's quite common, for example, to see a clause allowing a trustee to lend money to his charity in return for payment of interest at a reasonable rate. And equally, it's common to see a power to pay a trustee in return for the provision of professional services or other types of services. Now, if you've got those powers, then the trustees can exercise them. But just a note of caution, always carefully minute the decision and ensure that what is proposed falls exactly within the power that you've got. Now, the second exception is where the Charity Commission has authorised it. And the third is the power to remunerate trustees, which is contained in what is in now Section 185 of the Charities Act. This is not a blanket authority. The exercise of this power is subject to a number of preconditions and restrictions. So, for example, it can't be exercised if there's an express prohibition in your governing document on trustee remuneration without getting consent to remove that. Most charities have got an express prohibition. Only a minority of the trustees can benefit at any one time, and you must count your spouse or another relative as a trustee for those purposes, if that's what's happening. There must be an agreement in writing between the charity and the trustee concerned, and the trustees, excluding the one who's going to be paid, must first decide that they're satisfied that it's in the best interest of the charity to pay that trustee and that the remuneration is reasonable. Now, usually this means you should test the market. You shouldn't just decide it's a good idea. You've actually got to go out there and find out if the market is going to produce a better deal for the charity. So last, I want to talk just very briefly about the role of the Charity Commission. So a charity which is established in England and Wales is required to register with the Charity Commission if its annual income exceeds £5,000, unless it's what's called an exempt charity. Now, there are very few exempt charities these days. Housing associations, which are industrial and providence societies and regulated by the Tenant Services Authority, they are still exempt, and I think they will remain exempt. Some higher education institutes, which are funded by the Higher Education Funding Council, they're still exempt. But many charities which have been exempt up until now are being required to register on a staggered basis. Now, in practical terms, most charities which exceed the £5,000 income threshold must register. So what happens when you are registered? Well, as I mentioned earlier, there are going to be changes to the role of the Charity Commission, which are likely to include increased regulatory powers. But for now, the Commission has got objectives functions and duties. Its objects are to increase public trust and confidence in charities, to promote awareness and understanding of the public benefit requirement, to promote compliance by trustees with their legal obligations in exercising control of the charity, to promote the effective use of charitable resources. You'll recall that this was described by the House of Commons Select Committee as being too vague and aspirational, and then to enhance the accountability of charities to donors, to beneficiaries and the general public. Now, the Commission's functions are to determine whether a body is or is not a charity, to encourage and facilitate better administration of charities, and to identify and investigate misconduct and mismanagement, and take remedial or protective action. And then there are some functions, those are the main functions, but then there are some others, determining whether public collections certificates should be issued. That's not going to see the light of day. Obtain, evaluate and disseminate information concerning the performance of the Commission's functions. Well, they've been hauled through the mill over the last year, and they're having to tell everyone what they do and justify their position, which I think is a good thing. And then to give information or advice to a Minister of the Crown on any of its functions, and they do that quite a lot. And then their duties: acting in a way which is compatible with their objectives, to act in a way which is compatible with the encouragement of charitable giving, whatever that means, have regard to the need to use their resources efficiently, have regard to the principles of best regulatory practice, in other words, to practice what they preach, have regard to the desirability of facilitating innovation by charities. I don't know who dreamed that one up. And then in managing its own affairs, to have regard to generally accepted principles of good corporate governance. Well, all of this is really interesting, but what these objectives and functions and duties do is give the Commission very wide regulatory powers. Their powers are quite extensive. They can enable a charity to make alterations to its governing document, for example, to change its objects in order to make them more relevant. They can give a power to remunerate to trustees for the supply of services and goods. They can give consent to something which trustees are not sure whether they've got the power to do, or where they might be nervous that they're exposing themselves to liability. And then on the regulatory side, the Commission say that they monitor a charity's report and accounts for evidence that it's complying with the public benefit test, that its money is being spent properly, that there aren't excessive expenses being incurred, etc. The Commission in reality relies very heavily upon whistleblowers to obtain information about charity. And the Commission has recently stepped up its enforcement powers in relation, as I said, to charities which are late in filing their accounts or which fail to do so. Now, if the Commission is concerned about financial abuse that's going on, after it's opened an inquiry, it's got powers to suspend and remove trustees, to appoint new trustees, and they can also appoint a receiver, which they have done quite a lot. I've acted for a few of those. And they do that where they're not satisfied that the charity is being properly run and that there's a risk to the charity's property. Registered by the Charity Commission in 1988, it's been around quite a long time. Its objects are to promote any charitable purpose for the benefit of the community in Birmingham and the Sandwell district of the West Midlands. And it does that by advancing education, furthering health, relieving poverty, need, hardship, distress and sickness. Now, in practice, it runs a community resource centre, a welfare advisory centre, a community radio station, and what they call a bicentennial abolition of slavery project, which is quite interesting. Most of its income comes from grants from Arts Council England, Heritage Lottery Fund, from Birmingham City Council, and it also gets advertising revenue from its radio station. Now, the Commission received complaints from a trustee of the charity who did some whistleblowing. He alleged that funds which had been held for some restricted purposes had been misapplied, that some trustees had been receiving unauthorised benefits and remuneration from the charity, and that the trustees had developed what he called an informal system of signing blank cheques, which were then completed as required by staff and the Treasurer. It was also alleged that unauthorised and unsecured loans had been made to another charity. Now, one of the lottery boards had also complained about unauthorised remuneration of trustees. So the Charity Commission opened an inquiry, and it found that a capital grant had been used which was for a restricted purpose, have been used for general revenue purposes, clear breach of trust. The chair, who'd been acting also as the chief executive at the same time, and the treasurer, who was acting as his assistant chief executive, they'd both been remunerated, despite the fact that the governing document contained an express prohibition on remuneration of trustees. Now, this had apparently been agreed at a meeting of the trustees. They'd just agreed it. The jobs hadn't been advertised, and no advice had been given on what was the going rate for the job that they undertook. And now the Commission obtained copies of cheques from the bank, which had been honoured, and they revealed that the treasurer had signed cheques payable to himself. The charity solicitor had apparently advised that those payments should stop straight away and recommended that the charity should be repaid. But the advice wasn't considered, funnily enough, by the trustees for some months after that, and it was only then that the payments were stopped. And the trustees didn't take any action to recover the money that had been spent. So that was another clear breach of trust. The Commission announced that it was going to conduct an inspection of the charity's books and its records. Now, the Treasurer tried to hide evidence of the pre-signed blank cheques, but the Commission found several torn-up pieces of the cheques in a bin somewhere, and they showed that the trustee had signed them. A number of explanations were offered to the Charity Commission for this. The Treasurer explained that the particular account to which the cheques belonged was dormant, and for safety reasons it was felt appropriate to tear up the cheques. Now, the Treasurer regularly held several of these pre-signed blank cheques in his cupboard, and apparently this had been the charity's practice for a very long time. And he had signed several of them payable to himself as well. So there we are. A small number of trustees, apparently acting without the authority of the board, had lent money to another charity which was in financial trouble. No professional advice was taken about the loan, and the principal on that loan was never recovered. Now, in fact, a lot of important management decisions had been left to 3 of the trustees, but there was no evidence of any governance procedures at all, or evidence of any proper delegation of their authority. So the Commission concluded that it would only be proportionate to take action against the Treasurer because there was evidence of fraud here, not just poor practices by the trustees, serious misconduct on the part of the Treasurer, and which, if true, obviously affected the material well-being of this charity. So the Commission suspended the Treasurer as a temporary and protective measure, and then they gave consideration to whether or not he should be removed from office. Now, his solicitor sought a review of that decision through the Commission's internal decision review process, but the review, which was conducted by the Charity Commission's own staff, it upheld the initial decision. Now, the Commission subsequently gave formal notice to the Treasurer that it was going to remove him permanently from office, and the Treasurer and his solicitor again asked for that decision to be reviewed, and this time the review found in his favour, subject to some safeguards being put in place for proper financial management in the future. Now, what I would say to you is that this happened a couple of years ago. If it happened today, I don't think that he would have been allowed to stay in office. I think it would be a much tougher practice, however. That does tell you a bit about the way the Commission was behaving up until recently. Now, the Commission likes to end its reports with lessons for other charities, which are a bit patronising sometimes, but in this case they were that charities need robust and adequate financial controls, fair enough. Signing blank cheques is dangerous. The practice of signing blank cheques is a failure by the trustees and potentially their duty to preserve the assets of the charity. Committees should have clear delegated authority, it should be in writing, otherwise decisions should only be taken collectively by all of the trustees together. And trustees must accept ultimately the responsibility for directing the affairs of the charity. Now, in the course of this inquiry, the Commission exercised a lot of its powers, ordering the production of documents and information. It was like extracting teeth, apparently, freezing the charity's bank accounts, preventing the Treasurer from doing what he was doing, and finally suspending the Treasurer. We're now going to move on to another charity with a name that I can't pronounce, so I'm going to call it TBDS for short. It was registered with the Charity Commission in 1994. Its objects are to advance the Islamic religion, advancing education in Islamic studies, and relieving poverty. Now, in practice, it mainly provides facilities to the local Sufi community, which is in southwest London, for worship, and it runs education classes for children. It's part of a worldwide network, and it's got links with the Sudanese branch of that network. Now, the Commission received what it called credible information in the Charities' annual, suggesting that the financial information which was contained in its annual return was incorrect, because large sums of money were being transferred in and out of the Charities' bank accounts in cash. Now, first, the Commission considered whether the charity had provided false or misleading information to the Commission. The trustees hadn't filed accounts in the belief that the charity's income fell below the threshold for submission of full accounts, but they failed to take into account some of the charity's restricted funds which were held in the savings account. They just forgot about them. Didn't exist. Now, the Commission advised the trustees about this and informed them of their duty to provide accurate information about the finances. However, in the following year, the trustees again submitted inaccurate information, and when they were questioned, they admitted that their financial records were in a slightly chaotic state. So they said that they had submitted the form with inaccurate information rather than missing the submission deadline. Second, the trustees couldn't provide a satisfactory audit trail for the income and the expenditure, and large sums of cash were regularly used in their transactions for which there were insufficient records. The trustees couldn't provide a clear explanation of the charity's financial position. The trustees apparently operated quite a complex system of loans and donations to members, and a number of the trustees had benefited personally from the loans that were being made to and from the charity. The trustees were unable to distinguish when they were asked between the loans and the donations, so it was all a bit problematic, really. Money which seemed to have been donated to the charity was then repaid to members on request. So, it wasn't clear whether two payments to the Sudanese branch were loans or whether they were donations. Funds donated for the purchase of a new worship centre were used to pay rent and to pay loans and donations to the Sudanese branch of the network. So there we are. And again, a chequebook was found which contained a number of signed blank cheques. A lot of people do that. No policies or procedures in place for governance, financial regulation. There were no terms of reference for individuals who were holding designated posts within the charity. No conflicts of interest policy in relation to the loans. No child protection policy in place. That was an interesting one. There was no child protection policy in place, and none of the trustees had received any formal training or guidance on looking after children, given the laws that we now had. So the Commission's wider lessons here were that trustees must comply with their statutory obligation to maintain accounts. Information submitted to the Commission, funnily enough, must be accurate. That you must tell the truth, and providing false information is a criminal offence. And trustees must keep adequate financial controls in place. Cash transactions generally are more risky than cheque or bank card transactions. Cash transactions should be kept to a minimum. And where cash payments are made, they should be paid from a petty cash float and not from incoming cash, so where there's no record of what's happening. And then finally, holding the position of a trustee in name, but then not fulfilling the legal duties that go along with it, may amount to misconduct. Now again, in the course of this inquiry, the Commission exercised a lot of their powers. They restricted payments going into and out of the charity's bank account. They ordered the production of financial information, which didn't do them much good in this case. They directed the trustees to provide information, and they also directed them to implement good governance procedure. That's the first time I've ever seen them do that. They actually said, you must do X, Y and Z by, and they gave them a deadline for completion. Well, that is enough from me. I hope that you found that useful. It's not all sad. There's a lot of fun associated with being a trustee, but you've got to follow a few rules too.